Legally Speaking, with me, Tarun Nangia. This is a part of a very, very interesting series that we are doing after a statement that the Chief Justice of India made in court, where he said that we request the members of the bar not to seek unnecessary adjournments. Also, he highlighted this fact that 3,688 adjournment slips were circulated in the month of September, October, and added on that day when he made this statement, 178 adjournment slips were circulated. Now, this is something which he was forced to highlight. But what are the implications of adjournments on the economy, on the investment climate, and why the Chief Justice of India thought it is imperative to highlight this? This is what we're going to discuss today. Let me introduce my panel to you today. We have with us Pinky Anand, the Senior Advocate at the Supreme Court of India, Mr. Sanjay Jain, Senior Advocate at the Supreme Court of India. We have with us Niharika Karanjawala. She is with Karanjawala and Company. I have with us Sairam Subramaniam. He's partner with litigation team of Saraf and Partners. And we have an interesting mix of people. So we will get comments both from the business side, from what happens in Supreme Court, the practical issues, and all of that and more. Let me begin my show. May I request Senior Advocate Pinky Anand to give me an opening comment after I go to Mr. Sanjay Jain after this. Over to you, ma'am.
Thank you, Tarun. I think, in fact, this is something that I had spoken about 4 months back. And I do feel that when we are talking about the justice delivery system, one of the essential ingredients which one tends to bypass. I mean, in fact, what happens is we keep talking about increasing the number of strength of judges. We keep talking about quicker disposal by the judges. We keep talking about changing substantive law, which in fact also we are in the process of in various directions as far as the government is concerned. But we very often will not deal with the aspect of adjournments. And if you actually find the ground reality, the point is that we do seem to engage in, as the bar, into a number of adjournments which seem to be a cause of major concern. And therefore, the highlighting by the Chief Justice is at a very appropriate stage. The number of backlog of about 4 odd crores is something which is well known as far as the courts are concerned. The delay in the system is again something which seems to apparently really take us over, because it's something we are not able to deal with. In this background, I think this is what really has prompted, and the fact that on that particular day, of course, 174 odd adjournments were circulated, I think precipitated the situation to some extent, which is why the Chief Justice of India brought up this issue in the interest of justice delivery system.
Thank you for that opening comment. I'll go to Mr. Sanjay Jain, Senior Advocate at the Supreme Court. Mr. Jain, when you are arguing commercial matters in court to court, and when you see parties taking adjournment, sometimes in matters involving implications of, say, thousands of crores, does these thoughts like the interest cost, what is the burden on the company, all these go into your mind that in, say, a litigation of 4 years, if 1 year is wasted in adjournments, I'm talking from the lower court to the Supreme Court, what is the implication? Could you give me your opening comment and also what the Chief Justice of India was trying to put across when he said this?
In my view, Honorable the Chief Justice, though he mentioned the statistics only of Supreme Court, what he had in mind pertains to the entire justice delivery system across the country. And what he mentioned is this, that I mean, in the context of big corporate houses whose litigations are there at high stake courts, equally important is the pain and pathos of an ordinary citizen who is a litigant in lower courts. So when Honorable the Chief Justice spoke about it, he actually covered the entire gamut of it. So in my view, there are 3 types of adjournments, as we would say. One is completely unjustified adjournment, where the party has absolutely no justification, moral, legal, or ethical, to seek adjournment. So those kind of adjournments are something which frustrate the system and which frustrate the honorable judges and also the litigant, who is the ultimate consumer of the justice. Second point that I need to make is that there are types of adjournment which cannot be outrightly dismissed as totally unjustified, but with bit of alacrity and some planning, the lawyers and litigants together can avoid them. and which is now possible with the legal profession opening up so much new generation of lawyers coming, and the number of lawyers increasing. So the emphasis has to be, focus has to be on teamwork. Second chair counsel, third chair counsel, they should take up the responsibility to carry the matter forward. The third is and sort of an adjournment, which is justified in a situation there is some bereavement or some situation arising. So therefore, that is why even CPC, or for that matter, Salem Bar Association case, Supreme Court said that 3 adjournments ordinarily are okay. It is not that courts do not have power to give more than 3, but ordinarily they should not. So this is where the debate should actually circulate and percolate, that can there be a justification for more than a reasonable adjournment request, and how much impact it makes on the financial fortune of the litigant, because each adjournment costs, depending upon thousands to a crore of rupees.
Okay, you made a good point. Now, this is a very interesting panel. We have now two panelists, Niharika Karanjawala Mishra and Sairam Subramaniam, who front face with the clients. And they end up briefing people like Mr. Sanjay Jain and Ma'am Pinky Anand. So you are in court, but these people, if there is an adjournment, will have to hear the music from the client. So I want another set of views from these people. Over to you, Niharika Karanjawala Mishra, that what is the dilemma sometimes in the client's mind? What are the problems that he may face with adjournments? And see, we are talking of high stake commercial litigation here because we are of a view that anybody who invests money in this country generates jobs and contributes to the economy. But more than that, he is a provider of livelihood to millions of people, all these businesses. And that is why their litigation deserves that much of importance. Your view on what the Chief Justice said, why he said it, and what are the practical problems?
Right. So, Taran, excellent question. One being, what are the different types of ramifications on the clients? Now, you can see this, as Sanjay also pointed out, you can see this going all the way from huge multinationals and corporations right down to the everyday citizen. Primarily, it takes two forms. It's financial losses and it's personal losses of a kind, right? Like for a financial loss, one can easily imagine if you're looking at a mining company or something like that, mining operations are held up, let's say, an additional week, one can only imagine what that company is going to lose in terms of finances. Then just the more practical logistical things, even if that company or that client can afford to take that couple of days adjournment, couple of weeks adjournment, whatever it is, legal officers fly in often from out of state, right? Lawyers are engaged, lawyers who will, for every hearing, they are engaged. All of that piles up eventually. All of that has a significant financial impact upon the client. Then you look at the other side of it, and let's take criminal matters, for example, where there's a very high degree of personal cost involved, like supposing if a bail hearing is there, if it's an eviction hearing, something like that, people's lives are literally hanging in the balance, right? So even there, the personal cost to the client can be very high. And I think this is why the Honorable Chief Justice quite rightly mentioned that what needs to be avoided are unnecessary adjournments. I think that was a very important distinction, as Sanjay sir also pointed out, and Pinky ma'am also mentioned, because there are certain instances in which, unfortunately, it cannot be a matter cannot be proceeded with that day. There are certain instances in which an adjournment is imperative. However, the Honorable Chief Justice has very rightly, instead of just slamming the system in general and saying it's never an acceptable situation, pointed out that lawyers need to work to ensure that any unnecessary adjournment, just to either prolong the litigation or to knock it off to maybe what just might be a simpler day for them. If there is a way for the matter to go forward, it ought to go forward, not just in the interest of the litigants at hand, but also in the interest of the general public, lest these delays in the justice system result in the public losing faith in the courts. I think that was the Honorable Chief Justice's overarching concern, that it is damage done not just at the litigant level, which we can see clearly, but also to the system as a whole.
Thanks for that opening comment. I'll take this to Sairam Subramaniam, litigation partner at Saraf and Partners. Sairam, you front face with the clients. Many times you base with the city of Mumbai. When there are commercial cases and there are delays, for example, say when an arbitral award has to be enforced, the company has to get the money, or some other kinds of case. And then you compare this with the message that the Chief Justice of India is sending. Could you just give me that analysis?
Thanks, Tarun. Tarun, as Mr. Jain and Niharika rightly pointed out, the views of the Chief Justice come from both ends, from a commercial standpoint, as well as looking at the larger judicial system, backlog, pendency, everything that's put together today. Uh, you know, as simply as you can put it, the CJI, Honorable Chief Justice, has rightly and in fairness thought about the poorest litigant at the highest level, but has also thought about the commercials. Looking at it from a commercial standpoint today, the dilemma, of course, as you rightly said, there are many scenarios where arbitral awards go into enforcements, or there is a injunction that's operating against a party, an ex parte injunction that's operating against a party that needs to be vacated. Maybe my client is at the receiving end of that injunction where I'm not able to run an operation, but there are adjournments being sought, not at my cost, but the other side's cost, to prolong and delay the litigation. This is probably where the contours of CPC need to come into place. This is where the contours of procedural law need to come into place, where they need to identify whether the adjournment is justified or not. If the adjournment is justified, again, the CPC provides that reasons need to be given, reasons need to be considered before an adjournment is granted, whether those are being followed today. If the courts today take a more stronger view on understanding the reason behind an adjournment, I think that solves a lot of issues. That would put an end to a lot of delay in litigation that we see happening today. And one of the reasons that the Honorable Chief Justice also mentioned while giving the statistics was, non-availability of counsels. To that extent, today, the hybrid system of hearing that we have, the VC system of hearing that we have, may cut short counsels in another city. It still gives us access to do it. So there are ways and means to cut short, but the intent is right. How far do we execute it? How far do we see this being implemented at a very, very practical level is a challenge that we've seen in the country all these days, but it's not an insurmountable challenge. There are ways. Follow the rule as is given, and then you have a solution.
Okay, point well taken, Sairam. I will give you, this is a question for the panel and we'll take responses from each panelist. When investors in America or Europe sit down and they decide on a country to invest, I was told that enforcement of contracts and time taken for resolution of disputes numbered in days are presented to investors, where they go upon how many days will it take for me to get a final award in my hand, or for the contract to be enforced, or if there is a dispute, God forbid, then for the court order to come in days. And that also forms a criteria based on which they invest in a country. And more important, because after a lot of foreign companies have seen money being stuck in India, this has become a very important parameter. So to get investment in India, which will generate jobs, drive the economy, your dispute resolution has to be faster. So if it's 900 days or 500 days, those 300 incremental days, if they are just wasted in adjournments, that also matter a lot. Sometimes years are wasted in adjournments. We have seen in very high stake infrastructure matters also. You see that if, for example, it's a toll company, the toll company can completely go bankrupt in the process, or any of those kind of cases where high interest loans are taken at long tenures. All of this and more is there. Let me go to Ma'am Pinky Anand and then to the whole panel.
No, Tarun, I think you flagged it rather well, because considering that the world itself has become so commercially viable, and so has India, in fact, entered into this entire array. Considering that India is being, put out in the open, and the narrative is that it is commercially efficient, and we are inviting not only contracts within India, investment in India, but even advocating our dispute resolution system. And the dispute resolution system, indeed, we have come some way because of our substantive changes. For example, the Commercial Courts Act, which has brought into being and it has reduced the time frame for questioning and changing the course of litigation and making it much shorter. But nonetheless, today, with the world being the high stake matters, investments in India, and India being one of the most investor-friendly country in all senses, and we are wanting to invite and encourage investment into India, obviously even more so. So in that consideration, when people are deciding the course of action between countries, one is of course the stage of investment, and the second is the dispute resolution system. So in that, as you pointed out, the 300 plus days if there are adjournments, and delay incidentally in White and case has proven itself to be a major impediment. We were put into literally millions of dollars only on this account of delay and nothing else, not on substance. So therefore, the efficacy of a system and to improve it from the commercial aspect today has become a distinct reality, and we have to ensure that we take all steps in each of these directions, which includes a justice delivery system in the context of adjournments, to ensure that we don't have. Having said that, I do think sometimes, of course, as some of the speakers have said, it is indeed something to be looked at. But when there are interim orders which are carrying on forever or ad nauseum, or for example, where the petition needs to be dismissed, where the case needs to be dismissed and it's hanging on, a criminal case which requires to be quashed, each of these situations, bail to be granted, we do have to consider even more so the heartburn that it causes a litigant and the economy as a whole.
Point very well taken. I'll go to senior advocate Sanjay Jain. Mr. Jain, when you see the investors have to take a decision, and many times the investors looking at India will say, look, the award cost was X, the interest is now X plus 2, and there is no end in sight for this dispute. Won't he be scared to put in money? And is this why our Chief Justice is sending this message? That if India has to grow, then adjournments have to be lesser, dispute resolution has to be faster, within all the constraints that we have.
Absolutely, because when an investor puts in his money, he's concerned about the commercial aspects. And when a litigator comes to the court, especially in commercial division or in any ecosystem of arbitration or commercial litigation, whether in direct jurisdiction or otherwise, the focus or emphasis of the legal team is to get the dispute resolved at the fastest possible time. But here we need to do some empirical analysis. See, why do the adjournments occur? We have to directly link it to the length of hearing, which we actually have not applied our minds to. There are two types of hearings which shorter hearing and longer hearing. Now, we in India as a legal fraternity have to work out some kind of a system amongst ourselves to be able to start and conclude hearing within a reasonable time. What happens is this, that today we go and persuade the court to take up our matter, say 2 days after, 3 days after, the court gets persuaded, it starts. But I am unable to formulate my point, suppose in even in half an hour or 1 hour. So then the court has a heavy board. So therefore, only my matter cannot be consuming the entire time of the court. So then matter gets adjourned. So we have to see what are the reasons of adjournment, because the topic today is adjournment. So what are the reasons of adjournment? Because one of the reasons for adjournment is our inability to conclude a hearing within a reasonable time. And also the corresponding inability or reluctance of the court to bind the counsels to conclude their hearing within a reasonable time or within a prefixed time. So there has to be a system evolved where counsels are given fixed time. So the senior advocates, the counsels of the choice of the clients, they are able to commit their time in advance. They are able to commit their predefined quota of time, and they initiate and conclude the arguments within that time. Because otherwise, what happens is that to avoid adjournment, to avoid the optics of arrangement, the matter starts, but it goes on and on for months and years. So technically, the matter is part heard, but it is not concluded. So some empirical analysis and redressal approach has to be taken with regard to the length of hearing.
That's a fair point you made, that if you can break your argument into 3 parts, argue 2 points and take a date. We see that happening in Supreme Court many of these days. I'll go to Niharika Karanjavasra for his comment.
Right, Tarun. So, quite rightly, as you said, it does have a massive impact on the question of foreign investment, foreign companies investing. And, we've discussed this in other terms as well, such as bail in financial matters, things like that. And like I've always felt that one of the greatest impediments in this regard, and one of the greatest disincentives to to foreign investment in this regard, would be arbitrariness, right? Where there is the question of not quite knowing how long it would take, even though the Indian courts are burdened with a significant number of matters. Investors might be willing to say, all right, like you said, it'll take 500 days. But if there is then an additional arbitrary 300 days thrown in that nobody accounted for, that would potentially make that investor think again the next time, right? So even if this throws another spanner in the works in terms of foreign investment, because it makes those investors feel that they can't ever quite come up with a calculation, even if it's not a calculation in days, even if it's calculation in terms of months, it can't ever quite be a realistic calculation, and that would be a significant downturn. As Pinky ma'am rightly said, we are one of the most investor friendly countries at this moment. We are moving constantly towards that, and from that perspective, this is a very interesting aspect that members of the legal fraternity will need to look at for their own benefit, for the benefit of the entire country, to ensure that this does not prove to be a large scale barricade to us moving forwards in terms of foreign investment.
Thanks for that comment. I'll go to Sairam Subramaniam. Sairam, two things here. On account of delay, we see sometimes large companies are able to push through litigation when they hire, some of the top-notch lawyers that like the ones who are present on this panel today. But many companies with smaller investment corpuses, 400 crore, 500 crore, 1,000 crores, 1,500 crores, they are fairly big but not big enough. Maybe they can't work with the business names in the market. Their cases are stuck, they won't even make news. Many times the big cases make the news and that results in some kind of a push. But of course, that investor takes back news to his home country that in India there is no resolution. And then how much ever you convince, the money is not coming back again. In that view, what do you feel of our Chief Justice's push that he is doing?
Tarun, it's interesting because, with the amount of adjournments, the delays that happen, it's not only the advocates and the litigants who stand to lose, the country also loses out when judicial time is not respected. It's as simple as that. As you rightly said, if an investor were to go back to his home country and say, this is the delay that I have faced in, say, executing an arbitral award, in getting my money, in even as simple as having an injunction vacated, it's one, not going to reflect well on our judicial system and body, and two, it's not going to reflect well for the economy at large. So in that light, the comment made by the Chief Justice is with a view to showcase that India has the global capability in its applicable laws, in its laws as it stands today, for us to be more friendly to investor friendly states, to other investors coming in, to see that you have a resolution end to end in a time frame. It is possibly with this view that we've also seen recent enactments which have been stipulating time-bound manners of adjudication. So this is all well-rounded, and the CJI's comment, I think, has to be looked at in the right concept to say that we have the capability, there is a solution in place. It is just that we need to put our minds together to see that it's resolved.
Okay, point well taken. Now we move to a round of closing comments. We have 30 seconds for each panelist. Just want your comment on the kind of initiatives and push that our Chief Justice had been doing, right from listing of bail cases when he took over as Chief Justice, lauded as a very good move, to now pushing for lesser adjournments. We'll start with Ma'am Pinky Anand. 30 seconds for each panelist.
I think this is the most important part that the Chief Justice of India can play, and this is what is being done, is to send a message down the ranks. And that actually tends to expedite, put the system into a good perspective. I mean, even look at the book that the Chief Justice looked at, which is the gender, anti-gender statements that are being made and how to kind of modify that. The whole idea is actually to push forward a narrative, and that narrative is what really takes us forward.
Point well taken. Over to Senior Advocate Sanjay Jain.
According to me, Honorable the Chief Justice has given us a wake-up call. He has told us in no uncertain terms that, look guys, it's time to wake up, create an atmosphere, build up an ecosystem, build up an atmosphere in the court, build up a culture where all of you, the stakeholders of the justice delivery system, come together without equivocation and any kind of an ambiguity, that together, if we unite in this move to curtail the adjournments and deliver the justice faster for the litigants, it is in the common interest of all, not only the interest of the lawyers, but the litigants and the country as a whole.
Point well taken. Niharika Karanjawala Mishra.
So, Tarun, I think that's what's very clear here is this is a very progressive minded Chief Justice who is also focused on very practical solutions of how to move the courts forward, how to move the justice system forward, and is balancing all of those together into what will formulate the most efficient functioning for the justice system in a very practical way, not just a theoretical way. And I think that's what's most important here.
Point well taken. Sairam Subramaniam from Saraf and Partners.
Tarun, again, as everyone said, it's a very, very progressive step. It's a step in the right direction. But I think somewhere the responsibility lies with both the advocates to a large extent and the judicial officers to sort of see whether an adjournment is required. And it should be sort of tested on the touchstone of sufficient and reasonable costs. That is going to sort of lay the way forward on how we deal with such a situation. And yet, at the same time, a judicious and honest utilization of the provisions that we have under law today has to also be seen.
Point very well taken. I appreciate all of you could join me today on the program on this very important issue. Routinely, our Chief Justice makes certain points publicly known, also pushes certain, in a sense, messages right down to the district courts that he wants to do, which is a very welcome move. And stirs up a debate in society, which is another good thing, which he does via these utterances. We appreciate that we could do this show. He stirred up this debate. Of course, this will not end here. I know that now that he's said this, he's going to take this to some conclusion. But thank you each one of you for making time, and thank you viewers for joining us today. Thank you so much.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.